And joining us now on the debate for the full hour tonight, Bruce Ryder, law professor and assistant dean at Osgoode Hall Law School. Grant Huscroft, professor in the Faculty of Law at the University of Western Ontario. Kara Zwiebel, director of the Fundamental Freedoms Program at the Canadian Civil Liberties Association. Sunil Gurmukh, staff lawyer at the African Canadian Legal Clinic. And Marvin Kurz, legal counsel for B'nai B'rith Canada. And it's good to have everybody around the table here. So many newbies as well. Grant, welcome back to you, but first time for everybody else. Good to see you all. Let's do a bit of background on this William Whatcott case, because while you're all up to scratch on it, I'm not sure all of our viewers are. So, if you would, here's the background. By age 14, Whatcott was living on the street, and he was selling his body to older men for drugs and shelter. He then became a Christian, and 10 years ago started distributing flyers criticizing homosexuality. 4 people objected. They took Whatcott to the Saskatchewan Human Rights Commission, saying they were offended by his pamphleteering, which accused them of being sodomites and pedophiles, and they won. The SHRC fined Whatcott $17,500, but he appealed. On appeal, the Saskatchewan Queen's Bench overturned the Human Rights Committee ruling, and then the committee appealed to the Supreme Court of Canada, which has just heard the arguments and should announce its decision on this case in the spring. No one better than someone representing the B'nai B'rith could remind us all what the Keekstra case was about. You want to do that in 30 seconds or so?
Sure. James Keekstra was a teacher and mayor of Eckville, Alberta, and he used his role as a teacher to basically teach hate propaganda to his students. He basically made them memorize long tracts about hate propaganda, about the Holocaust being a lie, the Jews being the devil, things like that, and he was ultimately prosecuted. Keekstra was a criminal case, though, unlike Whatcott. At the same time Keekstra was heard, 2 other cases were heard, another criminal case and also a civil case, a human rights case, which is the case that you'll likely hear about a lot tonight, Taylor, which is about a guy named John Ross Taylor.
Bruce, pick up the story there, because there's the Taylor case, which you've talked about, and there's another case called the Oakes case. You think it's important to look at these in tandem. So what's the issue here? Marvin, what do you say on that?
The court has, in the past, found that hatred, like a number of other concepts, is capable of definition. When you say that you don't know what you can say, it's also true, I don't know what I can say about you in public. There's no statute that tells me what I can say about Steve Paikin in public. I'm not allowed to libel you. Hate laws deal in some ways with group defamation. That is, there are some things that are so odious that you can't say about a group because of the harm that that speech causes, that you shouldn't be allowed to do it. And there are 2 ways of dealing with it. You can deal with it under the criminal code, and you can deal with it under human rights law. And there are different ways of tackling the same problem.
This is all, though, Kara, in the eye of the beholder, presumably, right? Somebody's hate speech is somebody else's legitimate criticism.
We intervened, B'nai B'rith intervened to say that the law is constitutional, whereas what Bruce says is right. The law could have been drafted better. I think that the court, if it upholds the law, will tailor the law. The word tailor will probably be repeated over and over again.
Many different spellings.
Will tailor the law so that it's very clearly excised all the words but hatred. The other terms are irrelevant, and the other terms are not constitutional, but the term hatred has already been found to be narrow enough to be constitutional.
So you would acknowledge there is a difference between belittling someone and hating them?
Oh, completely. And
yet both those words are there in the Human Rights Code of Saskatchewan.
When that code was written, they threw in every word they could think of, frankly, not figuring out what the courts will have to say. Taylor told human rights legislators what is and what is not the limit. And subsequent cases, there in Saskatchewan in particular, which have limited that, the scope of the law, have basically said nothing else is constitutional, but hate clearly is. When you talk about money, $17,000, well, small claims court limited in Ontario is $25,000. You can get your butt hauled into court for $25,000, again, for libeling someone or for any number of civil matters. The idea of having a civil rather than a criminal remedy is to say that we don't want to overdo it. That there's some attempt to deal with hate speech in a way that doesn't bring the full state down on you. Yes, there is a legal proceeding, but there are all sorts of legal proceedings, both administrative and legal, that is in front of a judge. And they're all costly. The Children's Aid Society gets involved with your life. There's a bunch of bureaucrats that make decisions that can fundamentally alter your life. Ultimately, you can get in front of a judge, but ultimately, if you're not happy with what happens with a human rights tribunal, you can get in front of a judge as well. But there's one point, Grant, that you said, which is that that you shouldn't be trying to limit people's views. But the law really isn't strictly about people's views. You can believe whatever you want about gays, whatever terrible thing you want. The question is how you express it. If you express it in a way that's likely to create hate, that's when the law gets brought in. But it's based on a way that the Canadian law looks at a number of different forms of expression. On the one hand, you have freedom of speech, which is vitally important. I mean, the Supreme Court of Canada has made a number of recent decisions that have upheld the importance of freedom of speech. I think it was in a hate speech case that the court called it the lifeblood of democracy. So any discussion has to begin with that. But on the other hand, you have to think about the harm that the 20th century and the 21st century, we've seen how much harm can be caused by hate speech. I mean, the starting point, of course, is the Holocaust, where it was said that the gates of Auschwitz were paved from the words of Der Stürmer. You can go on and you can look at Rwanda, where there was a Canadian case 10 years ago where a guy who came to Canada named Mugesera helped precipitate the Rwandan genocide by calling Tutsis cockroaches who had to be exterminated. In Norway, just this summer, a bunch of kids were exterminated by a lunatic who had listened to hate speech about leftists and acted on it. So what we're seeing is that hate expression can have a lot of harm. Just as pornography is hard to find the limit, we've said that the limit is at harm.
Okay, Marvin?
But that's right. I think, for example, that Maclean's magazine subsequently published another piece by Mark Stein. There was a problem with the El Masri and Rogers case, which is the Maclean's case. For whatever reason, Maclean's was brought before 3 different human rights tribunals. In Ontario, where there is no commission to monitor and to have a gateway, but the Ontario Human Rights Commission said no. Then they went off and said something negative about Maclean's, which they probably shouldn't have said. They went to the Canadian Human Rights Commission, which deals with hate on the internet, and again, they said, no, we're not going to deal with it. Because there was a commission there, it looked at it, and it said, no, this doesn't rise to the level of hatred. Then they went to BC, where there is no Human Rights Commission, and went directly to the tribunal. But the wording of the decision was a ringing endorsement of freedom of speech. So, yes, Maclean's had to pony up a lot of money, but if Conrad Black or somebody wants to sue Maclean's, they're still going to spend 6 figures, and then they're still going to say whatever they think they should be saying. But, Grant does have a point, and for example, B'nai B'rith has called for a number of procedural remedies to be added to human rights law. Human rights law is not static, just like like libel law we've talked about. Human rights law has to evolve over time, and one of the areas in which I do think it has to evolve is in protecting the rights of those who are brought before human rights tribunals. So, for example, one area that should be considered is having costs. That is, in a case like Rogers, the people who brought Maclean's before the tribunal should be subject to costs.
How about Ezra Levant's case?
Ezra Levant's case never made it to a Human Rights Tribunal because the Human Rights Commission, well, actually never even made it past the Human Rights Commission because the gentleman who laid the complaint, Sohar Hardy, backed off. There was so much opprobrium against him that he backed
Ezra
off.
Had embarrassed him to the.
He embarrassed him. I mean, and he had. I mean, and there was no reason.
But it still cost him money. I think it still cost Ezra some money.
I don't know what it cost him. I mean, he says it cost him a lot of money, but all he did was he met with the Human Rights Commission. So he never set foot in a court or tribunal.
Marvin, that does open up a can of worms there, does it not?
Excuse me. There's 2 parts to it in terms of the idea of truth as a defense is problematic in both ways. On the one hand, the criminal code, for example, section, does have truth as defense. The reason that human rights law doesn't have truth as a defense, because, again, it's because it's harm-based. But, so the idea is that somebody goes and publishes something that says blacks are inferior. Do we want to have a human rights tribunal deciding whether that's true or not, or whether any of those kinds of allegations are true? Because human rights law will then be tossed on its ear, where one side is going to try to prove, excuse me, the truth of the kind of hateful speech that they're using. For example, Ernst Zundel tried to do that. I was there when he tried various and sundry tricks to be able to do that. And he tried to bring every juggler and clown of the Holocaust denial world in front of a tribunal hearing that he managed to spread out over weeks and months and years.
Do you think at the end of the day that was helpful? I remember that. I was in that courtroom too, and he brought a lot of, what do you want to call them? How do you want to characterize them? He brought a lot of
well, I call them jugglers and
crackpots, or what do you want to call them? Forward and we saw lots of headlines.
It was because of that ruling that he wasn't able to do even more to try to prove that the Jews deserve what they get. Because that's really what he wanted to do, and he wanted to prove the Holocaust didn't happen. He wanted to prove that it was a worldwide conspiracy and what have you. And then a term that's used often in criminal law, the administration of justice, would be brought into disrepute to allow something like that to happen. With regard to religion, it's not simply the Quran or the Bible, it's whatever, it's what you do with it. No one had a problem with the Bible per se. It was when a guy like Whatcott, or the American guy who goes around and says God hates fags and shows up at funerals, and he takes that he takes a biblical verse, and then he says that means that gays have no right to any life in society. That's the problem. So you can take anything in or out of context. You can take statistics out of context in order to try to prove something hateful. But it's not the religious part per se, but it's the use, it's the context in which you put it. Just briefly, what Whatcott did that took him over the line as well, and that brought him within the center of what human rights law is supposed to do, is that he was calling for discrimination, because the issue really had to do with teaching of gay matters in Saskatchewan public schools. And what he's saying is that all gays are pedophiles, which meant that he's saying that any gay teacher should be automatically thrown out, that any mention of anything having to do with homosexuality had to be dealt with in a way that eliminated the right to equality. That's the center, that's the discrimination. He was calling for discrimination, both against gay teachers and anything having to do with information relating to homosexuality. The test is whether different courts agree, then there'd be no appeal courts. I mean, the law evolves over time, and part of the way that the law evolves is that an important case may go from a lower court to a higher court and ultimately to the Supreme Court. And there may be 3 different decisions. There's nothing wrong with that. That's one of the ways the law evolves, and we've talked about that. Grant has talked about how the law of libel has evolved, and it has. And I've always thought that the law of libel was the bigger free speech issue anyway for a long time, and it has evolved. Any number of laws will change over time. Our family law has significantly evolved over time. So we can say that 30 years ago, when I first started practicing law, there was an idea that mothers should always have younger children. That's changed. But that doesn't mean that...
There was a law that...
It was called the tender years doctrine, where there was a notion that there was a presumption that a mother should have custody of a younger child.
Oh, I see.
So that was something that was not that many years ago. I would do something closer to what Sunil talks about and include probably elements of what Bruce talked about as well. The actual wording of Section 14.3 is a bit problematic, and we talked about it at the beginning of the show. I would strike that. I would uphold Taylor because the bottom line and the basics of Taylor remain true. However, moving forward, because the law has to evolve, there have to be newer procedural protections that the court can't impose, but that legislatures can. So it's partly the legislature, and it's partly the court that has to allow the law to move forward.
Clearly no ex-politicians on this group today who find it offensive that judges would tell them what to do with their laws. Note to self. Okay, Thanks, everybody, for coming in for a very thorough discussion about one of the very biggest issues that our Supreme Court is considering right now. Starting with, on the left-hand side of the table, Cara Zwiebel from the Canadian Civil Liberties Association, Grant Huscroft from the University of Western Ontario Law School. On the right-hand side of the table, there's Bruce Ryder from Osgoode Hall at York University, and Marvin Kurz from B'nai B'rith Canada, and finally Sunil Gurmukh from the African Canadian Legal Clinic. Good to have all of you with us tonight here at TVO.